non-conviction-based forfeitures are supervised by the courts. That's what they are. It's not you, the person involved or the accused person sitting with the Attorney General, prosecutor, and agreeing, and the Attorney General going to enter a null prosecutor.
That is correct.
Because this is beyond the reach of the court.
Yes.
Once you file a null prosecutor, the court can't say anything.
Then the Attorney General is a lawyer to himself.
So you shouldn't be calling it anything like non-conviction.
It's similar to it. It's not exactly the same thing, but as you said, this one is not. It's just a regime. It's a power that the Attorney General has and can exercise. And I'm thinking that he has this kind of regime at the back of his mind when doing these things.
And that again is applicable. That again is applicable because we need to educate our audience too.
Yes.
It's applicable to where the law enforcement ascertains and makes the conclusion that you have what your income cannot explain.
Yes. Yes.
This is a completely different thing.
Yes.
Like in the Constitution, Article 2864.
2864.
That if after your declaration of your asset, if we find that you have something which is not attributable to your income, attributable to inheritance, a loan, or reasonable earnings, then that will be forfeited because it is
you can't explain
it.
Yes. So, well, anyway, this is the route that he's chosen to go, and you know, we are where we are with it. So, what I'm trying to say is that the context which he provided was helpful, because without that, I think there will be serious questions that would have been asked.
Okay.
My question, which I'm asking myself, is that where is the punishment in all of this? Because there has to be a punitive element. Do we, for example, are we saying that these are people, or should we say, or probably we should say, that they should never be allowed to run a bank again or any financial institution again? They should not be allowed to even be directors of companies again, because you have managed things so badly.
Those are the rules, actually. So that is the situation. If your bank's license is revoked or your financial institution's license is revoked, this is the consequence you suffer.
Yes. Yeah. So we just have to make sure that, because they have a lot of related companies. They have a lot of related companies, and we are being told in Bright's expose, he said that some of these related companies have been resurrected or disguised under other names.
Almost 30 of them.
Almost 30 of them. So when I say what I say, I'm stretching into those related companies. Because yes, under Act 930, it's clear that what the consequences are. But we have to look beyond the face of it and look into some of these related companies. These related transactions that they've been involved in and all that. I mean, there's a lot of deception here. You know, a lot of deception and just hoodwinking the regulator. You know, and I'm not saying the regulator is innocent, because they should also have been able, their audits should have actually disclosed some of these matters. So I guess that's another argument for another day. What we all take heart in is the fact that with the null prosequi, the door is still open for punishment. Should they come across any new information or evidence that will warrant the case to be reopened. So I guess it's been packed rather than the doors shut firmly. Because if he had done a withdrawal, that would have killed the case. A withdrawal
after prosecution had closed their case.
Then that would have actually shut the thing down. But he chose to go down that route. So the fact that we can, you know, I guess the door is ajar, it's not completely shut. So let's see what happens next.